Okay, good evening, everybody. We're going to start the webinar now, and I'd like to welcome everyone to tonight's presentation on treating family members. My name is Cara Moroney. I'm the Director of Professional Conduct, and with me is Ryan Pastana, our Communications Officer, to assist and moderate the questions for me. I think everyone can hear, but if you're having any problems, just type it in now. And as always, feel free to type in any questions that you have as we go along. I'll take breaks to answer some questions if they're relevant to what I'm speaking about at that moment. And this presentation on the guideline, the Treating Family Members Guideline, which is out for consultation right now, it's not super long. So as we're going through some of the standards and how they apply to treating family members, if you do have any general questions about those standards, record keeping, fees and billing, if time permits, I can answer some of those general questions as well. But we will be doing more webinars as the year goes on different topics. So if it's something that might be coming up soon, I might not have time for that. Okay, so as I mentioned, we have a guideline that's out for consult until April 14th. And this guideline is called the Treatment of Family Members. So why this guideline and why now? How it came about is to give you some really broad background. Under the current reading of the Regulated Health Professions Act, the RHPA, it is considered sexual abuse to treat a spouse or a partner. And that's because when you're treating a spouse, the spouse is then considered a patient, and it is not permitted to engage in sexual activity with a patient. This issue of whether or not treating a spouse constitutes sexual abuse was reviewed by the Health Professions Review Advisory Council quite extensively, and recommendations were made to the Ministry of Health. And the Regulated Health Professions Act was amended to allow individual colleges to pursue a regulation which would exempt spouses from this definition. And it has been commented in some case law, and it was commented in this review by HPRAC, that this reading, the way it is now, it's been seen to be overly broad and unduly harsh. And that's mainly because when you're found guilty of sexual abuse at discipline, there's a 5-year mandatory revocation that comes with that finding. So the Patient Relations Committee of the college reviewed this issue, including that HPAC report and a lot of other materials, and they recommended to council to pursue the spousal exemption regulation, and council agreed. You know, they think that the automatically assuming that treating your spouse equals sexual abuse is not really just. And it diverts resources away from other sexual abuse cases. It ties the hands of the college and the discipline committee as to how they can deal with it, that we don't have a lot of discretion. Quote unquote victims or spouses in these cases don't necessarily perceive themselves as victims of sexual abuse. And it's a pretty heavy label to hand down to a practitioner that they're a sexual abuser simply because they were found to be treating their spouse. So the regulation will mean that treating your spouse isn't automatically considered sexual abuse. But that doesn't mean that treating spouses is a good idea. So when the Patient Relations Committee was reviewing this, they thought, well, if we're going to pursue the regulation that exempts spouses from the sexual abuse definition, we don't want to signal by extension that treating spouses is okay. So in tandem with pursuing the regulation, they wanted staff to develop clear guidance on this issue. And there are many reasons and we'll get to that, of why treating spouses is not a good idea. And for a lot of these same reasons also apply to family members as well. So by extension, we created a guideline that includes family members. And so even though the regulation is not in effect, and treating spouses is still prohibited until further notice, we thought that there was a lot of good information in the guideline that was developed, and it still applies with respect to family members and close personal relationships. So we thought we'd still go ahead and produce that guideline. And just before I move on to the next slide, I just want to kind of bring up why these graphics. We all like to, at first glance, I think a lot of practitioners might think, oh, great, yeah, it's great. I can treat my family members and my friends. It's great. I want to help them. I don't have to charge them. It's convenient. All these really great reasons. And it comes from a well-intentioned place, but it's very risky. And it's really important that people think critically and think ahead about all the pitfalls that can come with that. And we all like to think that our families would maybe not get upset or complain, but the reality is that they're sometimes the most likely to complain about us because of all the complicated emotions that can exist. And often when there's a personal relationship, complaints can sometimes come after that personal relationship has dissolved. So the person is upset with the practitioner and then they complain to the college. And whatever their motivation is, the college is mandated to investigate. And if you were in a conflict of interest by treating that person, then that's a concern. And the reality is that most families are probably fairly complicated. Most of us are not like the 1950s TV show, and it's risky to bring in another type of relationship, such as a therapeutic client relationship, which is supposed to be marked by a professional distance, which is almost the exact opposite of what a familial relationship is. So that's just kind of a introduction. So I just wanted to go through quickly how the guideline was developed so you understand the amount of work that's gone into it and what we've done to be thorough and validate it. So the Patient Relations Committee met in late 2014. They were looking at the regulation as well, as I mentioned. And then when they started talking about this guideline, they directed me to convene a working group of kinesiologists and canvass them to consider the issue of treatment of spouses and family members. So we did a call out, and in April 2015, we had 8 kinesiologists from various practice areas and various geographic locations in Ontario, both large and small, meet for a full day to help us develop this guidance. So we were very conscious about trying to get a diverse slice of the practice of kinesiology and get a variety of different perspectives at that table. So that group, the first thing that they did was broadly, they discussed the advantages and disadvantages of treating family members. And it was quickly seen that the disadvantages, or maybe more accurately called risks, were outweighed by those benefits. And a lot of them agreed around the table that it wasn't a good idea to be treating family members. And I think personally they all felt that they would never do it, despite their best intentions. Then the group broke off into, I think, pairs of 2 and looked at several specific standards and listed the risks and or considerations under each of those standards. The guideline was drafted, and for the most part, the guideline was somewhat drafted based on the format of how that day went. So if you've seen the guideline, you'll notice that we go through, I think, about 6 standards, which I'll go through in this presentation. The Patient Relations Committee has met twice since then to go over the guideline, and they made some further recommendations to the content and the tone. And the version that is up now has been approved by the Patient Relations Committee for consultation. We are not required to circulate guidelines, and we don't often consult on guidelines. First of all, they're not as enforceable as practice standards, and they're also more of a supplementary support to practice standards. So this guideline would be likely considered a supplementary support to the standard called professional boundaries. But the reason we're consulting on this guideline in particular is because when we went out on the consult for the spousal exemption regulation, a lot of the feedback came back in favor of pursuing that regulation, but the comments also went that much further by saying, yes, we should be able to treat our spouses. So it wasn't that people agreed not that it wasn't sexual abuse, but that they should also be allowed to treat spouses. So that kind of stimulated us to the idea that perhaps there's some practitioners out there that aren't really appreciating all the other risks that are associated with treating people that you have close emotional ties to, and we really want to ensure that we want to take the opportunity to ensure that kinesiologists understand why. We don't want to just tell you what to do and what not to do. That's not how we want to approach our members and how we want to approach regulation. We want you to understand why and use your sound judgment. Just a reminder again, feel free to type in at any time. So moving on to the guideline itself. And I've pulled these quotes directly from the guideline. So the principle, as stated in the introduction, is that it is generally inadvisable to provide treatment to family members except in exceptional circumstances. That's a mouthful, sorry. This is because despite a kinesiologist's intentions to deliver the best possible care, clinical objectivity may be compromised. This inherent conflict of interest, which we'll talk more about, it's not necessarily like a lot of other conflicts of interest where the best interests are competing, but it's a lack of objectivity due to other emotional connections in the relationship. It also affects professional boundaries, which are at the heart of any therapeutic-client relationship. And as we know, a healthy therapeutic-client relationship aids the effectiveness of treatment. When the working group had convened, often when they identified some of the potential benefits of treating family members, that same reason was also a risk as well. And the risks were generally considered to be on the greater. So for instance, one of the benefits that the group thought of for why you maybe would want to treat family members is that you might be able to gain greater compliance with a treatment plan. You know, maybe a family member wants to please you, or just trust you, or there's better supervision. Maybe you're helping them out at home. But it's also a risk. There's also a threat to compliance, because if you're treating your child, they might use it as a threat. Or if you get in a fight, the compliance might be threatened. People can leverage it. Well, I'm not going to do that if you do this. So yes, there might be some advantages, but the disadvantages are quite a bit outweighed. The scope of the guideline, we do have a definition of family member, which we looked at, and we borrowed heavily from the College of Physicians and Surgeons. And that is, a family member is defined as any individual with whom the kinesiologist has a familial connection and or with whom the kinesiologist has a personal or close relationship, where the relationship is of such a nature that it would reasonably affect the kinesiologist's professional judgment. The and or in there does allow for some discretion where, for instance, someone's technically a blood relative, so maybe you have a cousin, maybe you have tons and tons of cousins, but you don't really have a close tie. So there wouldn't be that same emotional connection. On the other hand, it also doesn't just include family. It includes non-blood relatives to whom there is a tie, such as a best friend or maybe an ex-brother-in-law. So you might have happened to be really close to your brother-in-law. Your sister divorced him. You're still really close. That would still be considered under this definition of family member. And the other limit to the scope of this guideline is it applies to treatment. And treatment is defined in the Healthcare Consent Act as anything that is done for a therapeutic, preventative, palliative, diagnostic, cosmetic, or other health-related purpose, and includes a course of treatment, plan of treatment, or community treatment plan. So basically, treatment does not include minor episodic care, such as applying ice to someone, or maybe your child comes home from a soccer game and they're sore and you do a little bit of manual release, or you're working out with a friend and you're providing some advice on their technique. That would be considered minor episodic care as opposed to ongoing clinical treatment. And also emergency care is always an exception. If someone falls unconscious and you need to revive them and it happens to be a family member, that is permitted. And then we come to exceptional circumstances. And this was, the Patient Relations Committee was very clear that treatment of family members and eventually spouses, when the regulation gets passed, should only happen when there is exceptional circumstances because the risks are too great. And they listed this is not really a definition of exceptional circumstances, but we listed some possible examples, like no other viable healthcare provider, demonstrated financial hardship. So you can't just take it for granted that someone might not have any money. You need to be able to show it. There's such a level of distrust or discomfort that someone is unlikely to see another regulated health professional. And you have the example up there of perhaps a family member who's been the victim of abuse and is not comfortable with anyone else touching them. You know, maybe you have someone who has agoraphobia and won't go out of the house, and maybe there's no home care available where you are. Those types of things, it's pretty exceptional, as you can see. Or there exists a real barrier to the patient-client accessing other healthcare services, so a severe communication disability. But I will note with these exceptional circumstances that, you know, they have to be real. You can't just say, oh, I checked that one and that's it, that's the exceptional circumstance. And sometimes you'll often have to combine some of these circumstances in order to create an exceptional one. So for instance, someone who has a severe communication barrier may not be an exceptional circumstance if you're living in Toronto, where there's a wide availability of practitioners, there's a lot of services available to break down that barrier. But if you're up in a small town, then maybe that does equal an exceptional circumstance. Exceptional circumstances must be well documented in the health record, and we'll get more to that when we reach record keeping. And the exceptional circumstances must be ongoing. If they cease to exist, then care must be transferred. And in fact, if any of these barriers do exist, there should be an ongoing effort to try to break down that barrier or get rid of that circumstance so that you can transfer their care as soon as possible. So we're about to move on now to talk about the specifics under each of the standards that were considered. Are there any questions at this time about the guideline in general? Okay, so we have a question about what about palliative care within your home as this is ongoing and where there might not be PSW or RPN support available around the clock? That's a good question. Often my understanding of palliative care, though, is that if there is an RN or a PSW, there will likely be a treatment plan in place that the people at home would just be carrying out during the hours when when that person isn't there. In terms of palliative, you might also be doing things that wouldn't technically be within the scope of kinesiology. There's lots of, activities of daily living, for instance. So I think that would be, I don't think that would be considered treatment. You would be assisting someone in their day-to-day activities, and I think that you'd be looking at someone else's treatment plan. If there was a circumstance where if you were trying to do something around kinesiology and you were creating your own treatment plan, I think, again, you might want to think about having someone else prepare the plan and make all the objective findings, and then there might be opportunities for you to just carry it out on their instruction. So I'm just reading one of the questions. Okay. There's a question about ergonomics, and that ergonomics is in the scope of practice, and just wanted to verify that ergonomic services should also be referred to other professionals. So yes, if you're an ergonomist, and it's the same. If you're a kinesiologist, whatever area of practice you're in, wherever you're thinking about providing treatment to a family member, we're saying that you shouldn't unless it's in exceptional circumstances. Ergonomics may be just a one-time assessment of someone, but we would still advise that that be referred to someone else to be completely objective. Because if you are doing an ergonomic assessment on a family member, you might think you know things that you don't. They may not. We like to think our family members tell us everything. They probably don't. So you may not be getting the full objective picture when you're trying to do that assessment. So it's the same scenario. Okay, so we'll move on to the first standard, and probably the most important standard of consideration for treatment of family members, and that is conflict of interest. The conflict of interest here is not like typical other conflicts of interest where you might have a financial or personal gain. It's the conflict between your emotional ties and your duty to be an objective clinician. So almost by definition, treating a family member is a conflict of interest, and that is why we're advising that it only be done in exceptional circumstances. And yes, while we agree that often you do have the best interest of the patient or the family member at heart, and we always talk about putting the best interest of the patient first, when there are emotional ties, these best interests are clouded by our own emotions. And there may be a tendency to overtreat, undertreat, or not recognize a problem at all. So some examples I just thought of. You might want to lose weight and you put them on an exercise program, but part of this is prompted by the fact that your kid is getting bullied at school. Or you maybe want them to be the best on the sports team. So, it's hard to kind of parse that out. Another example is maybe you're doing some exercise programming with your parent, and you're not noticing a decrease in their lung capacity because you don't want to admit to yourself that they're getting older. That's often a very hard thing for a lot of us to watch our parents get older. We don't recognize those signs. And that would be kind of an example of undertreatment. And the last example is planning an intensive period of treatment to help your friend prepare for a sports competition. And that's an example of maybe over-treatment because you're really wanting them to win. And maybe they really want to win too. So the interests are the same, but you're wanting it so much that you're tending to go a little bit overboard. The next standard that we've discussed is professional boundaries, and professional boundaries and conflict of interest are probably the two most significant standards to consider when you're looking at family members. So the professional boundaries, or the therapeutic client relationship, and this is taken from that standard, is based on respect, trust, and professional intimacy. So there is an intimacy in the therapeutic client relationship, but it's professional. And in most familial relationships, boundaries are by definition not professional. They're personal. That's why it's a personal relationship or a family relationship. So again, it's almost by definition, it's very hard to have professional boundaries when you have a personal relationship. If you are finding yourself treating your family members in those exceptional circumstances, it may seem artificial, but it really still is necessary to switch gears and to actively and consciously get into your clinician head. So you need to do things like have treatment take place during normal hours, normal locations, and these are also just good rules of thumb to maintain boundaries with any clients, obviously. The other consideration to think about for yourselves, if you're thinking, well, what's wrong if I treat a family member, is, okay, well, you might treat one family member and you do such a great job that then another family member comes and another one, and then you're treating tons of family members and you never get a break. So you're not getting your division between your work life and your personal life, and they become fused together, which can also be problematic for practitioners. I'm not sure this might be the case in undergrad kinesiology at this point, because it's not traditionally a professional program school. But obviously, when we think of doctors or other healthcare professionals, they are taught about not getting emotionally caught up in their patient's, client's life, their health status, their outcomes. They're taught to be empathetic and sympathetic, but they have to have that barrier. It would be too much to carry around all of the hardships of your patients or clients. So this is really hard to do when you're treating people that you're close to and that you have an emotional connection with, when often the goal is to not have an emotional, or the goal is not to have an emotional connect with your patients or your clients. And so the diagram here just shows, generally about professional boundaries. You want to be in that safe zone of care. And when you start blurring those boundaries, you tend to maybe become under-involved or over-involved. And with family, it's probably more likely that you become over-involved, and then you get out of that safe zone of care. You get out of that safety of the therapeutic client relationship, and that's where the risks happen. And it's probably greater in that teeter-totter. It's a bit of a teeter-totter type diagram. It's probably easier to teeter when you're in the context of a family member. Okay, moving on to consent and capacity. Every client must provide informed consent to treatment. So this includes if you're going to provide treatment to a family member. They must understand the nature of the treatment and appreciate the consequences. So for family members, part of this is knowing and appreciating that the family relationship may have an effect on the treatment. So you have to, when we talk about having consent discussions, you have to disclose any conflicts of interest. So you would have to disclose, I mean, it might be obvious if the person is your sister. You don't disclose to them, hey, I'm your sister. You disclose to them, you're my sister, and I can treat you because of these exceptional circumstances, but we need to be aware of you need to be aware that there might be a conflict here, and you have that discussion with them, and they still have to consent to you treating them under those conditions and under those exceptional circumstances. They need to know the risks, that you may not always be able to be objective, and that they have a right to a second opinion. They have a right to seek healthcare outside of you. In fact, they should be encouraged to do so. With respect to capacity, there's probably an inherent conflict of interest here. So for instance, if you're the parent and you're the practitioner and you want to treat your child, there's no age of consent. So your child has to be assumed capable of providing consent to treatment. And you may be inclined to say that they don't have the capacity to make that decision, and then you get to step in as the substitute decision maker and make that decision. So it's fraught with difficulty, and again, this is why we're saying exceptional circumstances only. Okay, the next one, fees and billing, which I think it might be my favorite. Because you know what they say, don't mix money or business with friends. So any relationships can get very sticky when you start involving any kind of business or money element into it. People don't like to talk about money, they don't like to talk about payment, and it gets especially sticky when you're trying to talk about it with ones that are close to you. And bringing up how a family member is going to pay you can be very awkward. But you have to be able to have that conversation. And if you can't have that conversation, then you might run afoul with the standard, which is our standard requires reasonableness, transparency, and consistency. If you are finding yourself treating family or friends in exceptional circumstances, be careful of charging different rates for different family members without that objective reasoning. You can't guarantee that family members aren't going to talk to one another, and they're going to find out that you're charging different rates. And this goes for, I'll just mention this generally, that if you are treating people who you don't consider to be, by the definition, family members. So let's say you are in a large town, you've got a large family, you've got lots of second cousins and third cousins. Again, you still want to be really consistent with what you're charging people. And if you are wanting to charge someone less, that might actually be a sign that that's telling you that that's a relationship that is personal to some extent, and maybe you shouldn't be treating them in the first place. The other thing the standard says is that if you are going to make the decision in an exceptional circumstance to treat a dependent, that you are not to charge them. And particularly since one of the exceptional circumstances might be demonstrated financial hardship, to turn around and then charge a person doesn't also really make sense. So be very, very wary of this area. One of the areas, this is also one of the areas where a lot of complaints originate, is when people are getting charged fees. And the very famous Leering case out of the College of Chiropractors, which is in the spousal context and actually spurred on, to some extent, the review of the regulation, started out with a complaint by the ex-girlfriend against the chiropractor, not about sexual abuse, but because after they broke up, the chiropractor turned around and billed her when he hadn't been billing her. So she complained about billing, but because that was before the spousal exemption regulation, the chiropractor lost his license for 5 years because it was found to be sexual abuse. So again, be very careful when it comes to money. And then the last two that we have are record keeping and mandatory reporting. And basically the two messages on these is that if you are going to be providing care to any family members in those exceptional circumstances, these standards apply without variation. So you have to keep a record, like a record the way you keep a record for every other client or patient, and they must be kept secure and confidential. If you're treating a child in your home, that record can't just be kept out in the open. It has to be kept secure. And again, you have to include that documentation on what the exceptional circumstances are and to keep up that documentation. Mandatory reporting, again, the same standards apply. There's no exception. So consider the fact that when you're treating someone, sometimes you find out some information that you may not have been privy to, even in your personal relationship, and you might come into a circumstance where you have to report one of your loved ones or family members. And this was an example that came up through the working group, was, you know, you might be treating a niece or a nephew, and you start to find lots of bruises that are not explained by your normal everyday life. Well, you know, if you're a regulated health professional and you find a patient that you suspect has been abused, you have to report that to Children's Aid Society. Well, now you're reporting against a brother or a sister or an in-law. So again, it's fraught with difficulty. So you just really need to think twice before you take on treating family members. So I'm just going to go back to I'm going to go back and talk about spouses for a bit here, because I want to make sure everyone's clear. We have submitted to government our proposal to have the regulation applied to us so that spouses will be exempt from the definition of sexual abuse. It is going to take a long time for that to go through. The government is very busy right now. So until you hear otherwise, there's no treatment of spouses. And if we receive a complaint or report that indicates that a kinesiologist has been treating their spouse, then we have to treat it as sexual abuse, and it's prosecuted as sexual abuse. So just don't do it, because even when the regulation is passed, we're still telling you don't do it other than in exceptional circumstances. Also note that the regulation will only apply to pre-existing spouses and partners, and for common law partners, you have to be together for 3 years. So if you treat your spouse, you treat your partner before the 3 years, it could also be considered sexual abuse. Obviously, it is never permitted to engage in an intimate relationship or date and then get into a sexual relationship and then marry a current client. That is without a doubt sexual abuse. And if you're, you know, if once the regulation is passed, someone complains and says this person's treating their spouse, you can't use that regulation if it's found that they're a spouse because you were treating them first. And that, you know, you started dating them while they were still a client. That is not permitted. It's always a good time. It's never a bad time to go over what sexual abuse is and professional boundaries. It's at the heart of the therapeutic client relationship, which is so needed for treatment to be effective and for this profession to be having public confidence. So remember that sexual abuse, the definition is broad. It includes words and actions of a sexual nature, not just contact. It can include your behavior towards coworkers and students or any supervised personnel, so anyone that you might have where you might be in a position of power. It can be your behavior not necessarily directed toward the client, but how clients see you observe your behavior in the office with other people. And so it's always really important to remember your professional boundaries. And you know, we've done a webinar on that, and we're probably going to redo one again this year, because again, it does bear repeating. And just I would bring it up at the end here, just because we are talking about sexual abuse, we are talking about professional boundaries, and that it's just always important. So if anyone has any questions, please feel free to type them in now. If you have any general questions about any of those other standards that we mentioned, I'm happy to answer them because we do have a bit of time. I think the next webinar will be on scope of practice. That seems to be a very hot topic, and that will probably be in May or June. If you have any burning questions now, please feel free to answer them. Or if you have any questions about the guideline, please go online and read it, and send us your feedback if you have any. Mostly we just want to make sure that it's clear. We're not trying to be hard on you by saying you can't do this. it's actually for the protection of the public. It's for the protection of you as well. Okay, so we have a question. Okay, so the question is, and I'm assuming you're talking about right now, currently, could treatment of is treatment of spouses an absolute no-no, even under the exceptional circumstances? That is correct. Right now, treatment of spouses is not permitted. The only, and remember the definition of treatment, as I said earlier in the presentation. So it doesn't include minor episodic care. So if your spouse comes home and you give them like a 5-minute massage, that's not treatment. Treatment has to have a treatment plan. It has to have, it has to have an assessment, or it has to have an assessment first, treatment plan. You have to have, all those elements of what you think about when you think of your clients in a clinic or a hospital or what have you. And it doesn't include emergency care. If minor episodic care turns into treatment, though, and for whatever reason someone finds out about it and complains, or you get divorced and your spouse decides to complain, minor episodic care can turn into the level of treatment. But that's the only exception as of now. Okay. Not seeing any other questions. If you have any questions that you didn't want to ask during the webinar, feel free to email me, or you can put them up on the consultation as well. And just to let you know that you will receive a follow-up email after the webinar that will be proof for your CPD purposes. So that will be coming to you automatically. And as always, you can use it for your QA CPD. So unless there are any other questions, we will wait another 30 seconds. Presentation is done for tonight. Okay, so there's a question here. A question about what the rule is for common law. So this isn't really an issue right now until the regulation comes into play, because as of now you're still not permitted to treat a common law partner or a spouse at all. When the regulation does come into effect, spouse is defined as someone you're married to, and but it also includes common law partners, and that definition is taken, I believe, from the Family Law Act. And in order to be considered a common law partner, you have to be cohabiting for 3 years. So that does raise the question that if you were treating someone who you were only living with for 1 year and you weren't married, it remains to be seen, but it may still have to be treated as sexual abuse. So yes, be careful of that 3-year. But it's not really an issue right now because the regulation isn't in effect. Question about, could you tell me the resources for the definition of treatment? Yes, the definition of treatment is found in the Health Care Consent Act. You can just Google it, it'll be on e-laws. And you can also find it in the our standard on consent on our website. It's also there as well if you don't want to go through the act. Okay, well, we're almost at an hour, a little bit earlier than, it wasn't a very long presentation. So I'm going to say good night. Have a good night, everybody. And again, if you have any questions, feel free to email me. And I hope you're not out there trying and spread the message to your colleagues that as much as they might want to, it's not really advisable to treat your family members. Thank you. Good night.